Mr. Deakins.
Thank you. I just have a few comments to make. I do think that the proposed rule has aptly been described by the minority view as election now and hearing later, which means a lot of essential issues do not even receive potential pre-election consideration by the board. And I think there is a very serious legal question as to whether this rule will be considered legal ultimately. It almost invites employers to file litigation to set aside these rules. I think the approach clearly violates Section 9C, and the legislative history shows that. If you go back to Senator Taft's statements in 1948, he said in describing the pre-election hearing, quote, "It is the function of hearings in representation cases to determine whether an election may properly be held at the time, and if so, to decide questions of unit and eligibility to vote." And in the 1978 discussions in Congress, Congress again said that pre-election hearings must address all election issues, including issues of voter eligibility, and they rejected proposed amendments that would have implemented shortened pre-election periods without hearings on unit scope and voter eligibility issues. I also think that the rule, to the extent that it gives the hearing officer discretion to make decisions, is clearly in violation of the statute. The hearing officer's role, as I've always understood it, is to simply create a record, and that's it. He has no authority to do anything else. So I really feel like the board is getting too close to the edge of the law in some of the things it's doing with this rule, and I think it's almost inviting litigation, which is most likely to occur. Excuse me, I'm sorry. I wanted to make only one final comment on post-hearing briefs, and that is the real advantage is that if you are able to file briefs, you have a written transcript of the record, and that's not something you can have on an oral argument. And I think that's a very important thing. And one final note, the comment that this is like an arbitrator issuing a decision and saying, "I'll send my opinion to you later," that's not anything like what we're talking about here. What we're talking about here is directing an election and this making a decision later. It's not a matter of, "This is my decision and I'll write you opinion later about it." There is no decision. It's simply a direction of election with something to come later.
Just one quick thing. What if it's just one or two issues that are really separating the parties? Do you have a problem with having oral argument at that point?
A record is still helpful. And it seems to me that it's important, at least certainly from an appellate standpoint, to be able to argue in a written brief what's in the written record. So yes, I would say in all cases, which, as I understand, is the existing practice of the board today.
Mr. Deakins, to mention something that I had mentioned earlier, we have this current practice, which is 7 days. For the time being, I'll exclude the possibility of an extension. There's also a potential issue of a request for review to the board. If we were to preserve the current practice with respect to post-hearing briefing, which provides a roadmap to some degree for the only permissible decision maker, that is the regional director, to actually base his or her decision on the record. And if we took the equivalent amount of time and found a way to squeeze it out of our internal procedures for evaluating requests for review, is that an approach that you would find to be objectionable as to this particular issue?
It would not be objectionable to me, Your Honor, no.
Okay, thank you.
Because you're not taking away any privileges that the employer has.
I would ask you to think back to the representation cases that you've handled through to a decision. In how many of them do you think that you would have been unable to adequately point out the relevant evidence and make the legal arguments in a closing statement?
Well, I would say in most of them. Because in a case where you have competing witnesses, at least, I think it would always be the case. Because you gotta look at all those testimonies together and try to figure out where to come out between all those witnesses.
Thank you.
Thank you very much.